Good morning, everyone. Happy Monday. Join Jackie Mondays at 10. Today's topic is about removing an executor. Now, this is in terms of once someone has passed away and the executor is then acting in the estate. So, of course, the other scenario where you do your will, you can change your will at any time. Your will's not in stone. So if you had put an executor in your will in one point and then wanted to change that person, that's easy. That's no problems. This is if someone in your family has passed away and the executor under the will is acting in that estate and maybe it's not going so well. So if the executor is not doing their job, either they haven't brought the will to court or they are taking too long or they're not following the will, then there's certainly grounds to remove an executor. So it can be done. It is, however, a Supreme Court action. So be aware that you would have to commit to paying some fees to get that done. And it's not necessarily the case that the estate would pay those fees, particularly if you were unsuccessful removing the executor. So the executor actually has to be doing something wrong legally or not doing their job to be able to remove them. It's not just if they're uncooperative or uncommunicative. If they're still doing their job, then there won't be grounds to remove them. So firstly, an executor has to bring the will into court promptly. If they haven't actually started the administration within 12 months to 2 years, yes, that is grounds potentially to make an application for them to bring the will to court and actually do their job. And at that point, you could challenge whether there's someone more appropriate to do their job. If they have already started the administration and it is taking years, then yes, maybe it's too much for them and they're incapable. So that could be grounds as well for an application. Or if they are blatantly not following the will, that's certainly grounds, because an executor is supposed to act in accordance with the will and uphold the will and uphold the law. But if they are doing things for their own benefit, or they're favouring certain beneficiaries, or they are just going, oh, we'll just change that and do this, that's not what they're allowed to do. So yes, that's another grounds to commence court proceedings to have them removed. If you start those court proceedings, you have to either be prepared to put your hand up yourself to then volunteer to do the job, or the court will generally default to state trustees. So you also have to be prepared that there is a consequence of making that application, and it may end up in the hand of the state trustees, who may or may not be much better in terms of time taken to do the job. So I hope that was helpful. If anyone else in your life has a situation like this, then please share this with them. Either tag them in the comments below or share it with them via Messenger if you want to keep it private. This video, while live at the moment, will be saved onto the page. It goes into the archive with all the videos on our Facebook page there. So please use that as a resource for your friends and family when something goes wrong, and it's a great first place to start. There are hundreds of videos there. And of course, if you have a particular question you'd like me to address, please direct message us here on Facebook and we can answer your question, or our email us at admin@tbalaw.com.au, or on our website, Meet the Team page. All our direct email addresses are available there. I hope you have a great week. I'll see you again next Monday.